Meaning of specific or determinating. The above provision refers to an obligation specific or determinating. A thing is said to be specific or determinate, particularly designated or physically segregated others of the same class. Meaning of the generic or indeterminating. A thing is generic or indeterminate when it refers only to a class or genus to which it pertains and cannot be pointed out with particularity. Duties of debtor in obligation to give a determinating. Preserve the thing. In obligation to give real obligations, the obligor has the incidental duty to take care of the things due with the diligence of a good father of a family pending delivery. Deliver the fruits of the things. This is discussed under Article 1164. Deliver the accessions and accessories. This is discussed under Article 1166. Deliver the thing itself. Article 1163, 1233, 1244 as to kinds of delivery. Answer for damage in case of non-fulfillment or breach. This is discussed under Article 1170. Specific thing and generic thing distinguish. A determinate thing is identified by its individuality. The debtor cannot substitute it with another, although the latter is of the same kind and quality without the consent of the creditor. Duties of debtor in obligation to deliver a generic thing. They are 1. To deliver a thing which is of the quality intended by the parties, taking into consideration the purpose of the obligation and other circumstances. 2. To be liable for damage in case of fraud, negligence, or delay in the performance of his obligation or contravention of the tenor thereof. Different kinds of fruits. 1. Natural fruits are the spontaneous products of the soil and the young and other products of animals. 2. Industrial fruits are those produced by lands of any kind through cultivation of labor. 3. Civil fruits are those derived by virtue of a juridical relation. Right of creditor to the fruits. The creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery arises. The intention of the law is to protect the interests of the obligee should be obligor commit delay, purposely or otherwise, in the fulfillment of his obligation. When obligation to deliver fruits arises, generally the obligation to deliver the thing due and consequently the fruits thereof, if any, arises from the time of the perfection of the contract. Perfection in the case refers to the birth of the contract or to the meeting of the needs between the parties. If the obligation is subject to a suspensive condition or period, it arises upon the fulfillment of the condition or arrival of the term. However, the parties may make a stipulation to the contrary as regards the right of the creditor to the fruits of the thing. Meaning of personal right and the real right. Personal right is the right of power of a person, creditor, to demand from another debtor as a definite passive subject the fulfillment of the latter's obligation to give, to do, or not to do. Real right is the right of interest of a person over a specific thing, like ownership, possession, mortgage, without a definite passive subject against whom the right may be personally enforced. Personal right and real right distinguish. In personal right, there is a definite active subject and a definite passive subject, while in real right, there is only a definite active subject without any definite passive subject. A personal right is therefore binding or enforceable only against a particular person, while a real right is directed against the whole world. Ownership acquired by delivery. Ownership and other real rights over property are acquired and transmitted in consequence of certain contracts by tradition. or delivery in sale. For example, mere agreement on the terms thereof does not affect transfer of ownership of the thing sold in the absence of delivery, actual or constructive of the thing. Meaning of accessions and accessories. Accessions are the fruits of a thing or addition to or improve upon a thing. Accessories are things joined to or included with the principal things for the latter's embellishments, better use, or completion. Rights of creditor to accessions and accessories. The general rule is that all accessions and accessories are considered included in the obligation to deliver a determinate thing, although they may not have been mentioned. This rule is based on the principle of law that the accessory follows the principal. In order that they will be excluded, there must be a stipulation to that effect. Situations contemplated in Article 1167. Article 1167 refers to an obligation to do, example, to perform an act or render a service. It contemplates three situations. Number 1, the debtor fails to perform an obligation to do. Number 2, the debtor performs an obligation to do but contrary to the terms thereof. Or number 3, the debtor performs an obligation to do but in poor manner. Remedies of creditor in positive personal obligation. If the debtor fails to comply with his obligation to do, the creditor has the right: A. To have the obligation performed by himself or by another, unless personal considerations are involved at the debtor's expense, and B. To recover damage, in case the obligation is done in contravention of the terms of the same or is poorly done. It may be ordered by the court upon a complaint that it be undone if it is still possible to undo what was done. Performance by a third person. A personal obligation to do, like a real obligation to deliver a generic thing, can be performed by a third person, while the debtor can be compelled to make the delivery of a specific thing. A specific performance cannot be ordered in a personal obligation to do because this may amount to involuntary servitude, which as a rule is prohibited under our Constitution. Remedies of creditor in negative personal obligation. In an obligation not to do, the duty of the obligor is to abstain from an act. Here, there is no specific performance. The very obligation is fulfilled in not doing what is forbidden. Hence, in this kind of obligation, the debtor cannot be guilty or delay. Meaning of delay. The word delay, as used in the law, is not to be understood according to its meaning in common parlance. A distinction, therefore, should be made between ordinary delay and legal delay in the performance of an obligation. Number 1, ordinary delay is merely the failure to perform an obligation on time. Number 2, legal delay or default or mora is the failure to perform an obligation on time, which failure constitutes a breach of the obligation. Kinds of delay or default. They are mora solvendi, or the delay on the part of the debtor to fulfill his obligation, to give or to do. Mora accipiendi, or the delay on the part of the creditor to accept the performance of the obligation, and compensatio more, of the delay of the obligors in reciprocal obligation, like in sale. Example, the delay of the obligor cancels the delay of the obligee, and vice versa. The net result is that there is no actionable default on the part of both parties. No delay in negative personal obligation. In an obligation not to do, non-fulfillment may take place, but delay is impossible, for the debtor fulfills by not doing what has been forbidden him. Requisites of delay or default by the debtor. There are 3 conditions that must be present before mora solvendi can exist or its effect may arise. Number 1, failure of the debtor to perform his positive obligation on the date agreed upon. Number 2, demand, not mere reminder or notice made by the creditor upon the debtor to comply with his obligation, which demand may be either judicial, when a complaint is filed in court, or extrajudicial, when made outside of court, orally or in writing. And number 3, failure of the debtor to comply with such demand. The above presupposes that the obligation is already due or demandable. Grounds for liability. Number 1, fraud, negligence, delay, contravention of the terms of the obligation. Responsibility arising from fraud demandable. This provision refers to incidental fraud which is employed in the fulfillment of an obligation. Responsibility arising from fraud can be demanded with respect to all kinds of obligation, and unlike in the case of responsibility arising from negligence, the court is not given the power to mitigate or reduce the damage to be awarded. This is because fraud is deemed serious and evil that is employment to avoid fulfillment of one's obligation should be discouraged. Waiver of action for future fraud void. According to the time of commission, fraud may be past or future. A waiver of an action for future fraud is void, no effect, as if there is no waiver, as being against the law and publicly policy. A contrary rule would encourage the perpetration of fraud because the obligor knows that even he should commit fraud, he would not be liable for it, thus making the obligation illusory. Waiver of action for past fraud void. What the law prohibits is waiver anterior to the fraud and to the knowledge thereof by the aggrieved party. A past fraud can be the subject of a valid waiver because the waiver can be considered as an act of generosity and magnanimity on the part of the party who is the victim of the fraud. Here, what is renounced is the effect of the fraud, that is, the right to indemnity of the party entitled thereto. The waiver must be expressed in clear language which leaves no doubts as the intention of the obligee to give up his rights against the obligor. Responsibility arising from negligence demandable. In the performance of every kind of obligation, the debtor is always liable for damage resulting from his negligence. The courts, however, are given wide discretion in fixing the measure of damage. The reason is because negligence is a question which must necessarily depend upon the circumstances of each particular case. Moreover, negligence is not as serious as fraud because in the case of the former, there is no deliberate intention to cause injury or damage. Validity of waiver of action arising from negligence. An action for future negligence, not fraud, may be renounced except where the nature of the obligation requires the exercise of extraordinary diligence, as in the case of common carriers. Thus, in the preceding example, the law allows an agreement between S and B, whereby S will not be liable for damage arising from negligence in the performance of his obligation. But if S is a common carrier, example, bus, shipping, or airline companies, such waiver is void. Where negligence shows bad faith, example, deliberately committed, it is considered equivalent to fraud. Any waiver of an action for future negligence of this kind is therefore void. Kinds of negligence according to source of obligation. They are: number 1, contractual negligence, number 2, civil negligence, and number 3, criminal negligence. Meaning of fault or negligence. Fault or negligence is defined by the above provision. According to our Supreme Court, the negligence is the failure to observe for the protection of the interests of another person that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury Factors to be considered. Negligence is a question of fact, that is, its existence being dependent upon the particular circumstances of each case. In determining the issue of negligence, the following factors must be considered. Number 1. Nature of the obligation. Example, smoking while carrying materials known to be inflammable constitutes negligence. Number 2. Circumstances of the person. Example, a guard, a man in the prime of life, robust and healthy, sleeping while on duty is guilty or negligence. Number 3. Circumstances of time. Example, driving a car without headlights at night is gross negligence, but it does not by itself constitute negligence when driving during the day. Number 4. Circumstances of the place. Example, driving at 100 km per hour on the superhighway is permissible, but driving at the same rate of speed in Ayala Avenue, Makati, is gross recklessness. Kinds of diligence required. Under Article 1173, the following kinds of diligence are required. Number 1. That agreed upon by the parties orally or in writing. Number 2. In the absence of stipulation that required by the law in the particular case, like the extraordinary diligence required of common carriers. And number 3. If both the contract and law are silent, then the diligence expected of a good father of a family. Meaning of fortuitous event. A fortuitous event is any event which cannot be foreseen, or which, though foreseen, is inevitable. Stated otherwise, it is an event which is either impossible to foresee or impossible to avoid. The essence of a fortuitous event consists of being happening independent of the will of the debtor, in which happening makes the normal fulfillment of the obligation impossible. Fortuitous event distinguished from force majeure. A fortuitous event may either be an act of man or an act of God. Number 1. Acts of man. Strictly speaking, fortuitous event is an event independent of the will of the obligor, but not of other human wills. Examples: war, fire, robbery, murder, insurrection, etc. Number 2. Acts of God. They refer to what is called measure of, or those events which are totally independent will of every human being. Example, earthquakes, flood, rain, shipwreck, lightning, eruption or volcano, etc. Kinds of fortuitous event. In speaking of the contract of lease, our civil code distinguishes between two kinds of fortuitous event, namely, number 1, ordinary fortuitous event, or those events which are common and which the contracting parties could reasonably foresee. Example, rain. Number 2, extraordinary fortuitous event, or those events which are uncommon and which the contracting parties could not have reasonably foreseen. Example, earthquake, fire, war, and unusual flood. Meaning of presumption. By presumption is meant the interference of a fact not actually known arising from its usual connection with another which is known or proved. Two kinds of presumption. They are, number 1, conclusive presumption, one which cannot be contradicted, like the presumption that everyone is conclusively presumed to know the law. Number 2, disputable, by presenting proof to the contrary, like the presumption established in Article 1176.